You're watching Behind the Headlines. I'm Pacchia. We've talked before on this show about financial regulatory reform laws such as Dodd-Frank and the challenges regulators face in terms of bringing finalized rules online and into full effect. Parties opposed to financial reforms have scored some notable victories in the courts recently, but my guest today says this bodes poorly for almost everyone involved, including the banks. Joining me now is Mike Konczal, fellow at the Roosevelt Institute. You may know him under his blogger handle, Rortybaum. Welcome. Thanks for coming in to see us.
Thanks for having me.
Of course. So you recently wrote this really interesting piece for Bloomberg View in which you wrote that the courts have been playing an outsized role in financial regulatory reform. How so?
So when Dodd-Frank passed in July of 2010, we understood that, it was going to be a very difficult battle for implementation. There's going to be a lot of lobbying. There's a lot of uncertainty about how the regulators would end up enforcing some of the key parts. And there are kind of three big battlefields. One was actually just the rule writing procedure. One was whether or not Congress would go back and change parts of it after the fact. And the third would be the courts, judging whether or not the rules would be implemented correctly with the law. Lobbying has been a very it's a huge part, but we've always understood that lobbying would be a big problem for Dodd-Frank. The courts, on the other hand, have made some really big decisions that have hung over the entire process in a way that we did not expect.
When you look at the last 3-4 months, which decisions jump out at you?
Well, the big decisions were in 2011, essentially. There was a decision, Business Roundtable versus the SEC, which threw out proxy access rules. And there was another decision that essentially, at the end of last year, that threw out position limits from the CFTC. Those have had a chilling effect on all the regulatory reforms, and they've really put a real hamper in how we approach the process.
And it's bad for people who want to see financial regulatory reform, obviously. But you also said in this piece, which I thought was really interesting, that this is ultimately going to hurt banks in the end. Why is that?
Well, I understand why banks want to fight on these terms.
Winning lawsuits is great. It must feel awesome to win a lawsuit.
And it's crucial to understand that the courts themselves are really going to be biased in three key ways. One is that people who think the law should go further have no standing in court. So the only cases courts will hear are the ones that essentially pull back on regulations. They also tend to be thumbs up or thumbs down procedures. There's not lobbying at the margins to water down a rule. These rules are going away and then they're not coming back.
Right. So instead of poking out a small provision of a broader rule, generally speaking, a judge is just going to say, let's throw the whole rule out.
Right. And then the third is the kind of chilling effect. So, the fact that one major rule is thrown out means that, suddenly all the rules are going to be slowed down. All the rules are going to have to become much more cumbersome to meet court standards that are very uncertain at this point. Why might it hurt the banks? A lot of people think Dodd-Frank does not do very much. A lot of people are concerned that the financial regulation apparatus that's going to come out of the Obama administration will be insufficient to really rein in too big to fail. You're seeing this already with really bipartisan talks about whether or not too big to fail is ended. If it looks like the law is essentially illegitimate or unable to do what it needs to, you're going to see reformers come back with much harsher provisions on capital, on breaking up the banks, on Glass-Steagall, that the banks successfully avoided the first time around.
Yeah, I wanted to get to that point. Is it better to have a watered-down Dodd-Frank or no Dodd-Frank at all if you're in favor of financial regulatory reform?
It depends on which parts we're talking about. I think there are places where if it was pulled back, you'd still have a good infrastructure. But it's like thinking of it like a net or like a system that's meant to hang together. It's not so much that any one part's a little squeakier than others. If parts of it don't work, then the other parts have to work much better to make up the difference. I think the other thing is that we need to have an expectation of what it's supposed to do. And I think if you have rules that are very piecemeal, if you have rules that require a lot of regulator discretion that we can't always count on, you're going to question whether or not it's going to do it. It's all going to hang together in a way that accomplishes the goals we need.
So what to do? Would it be best just to scrap this and try again?
Well, I think, first of all, we need, there's a lot of judicial vacancies. And if President Obama was much more vigilant in 2009, 2010, when they had the Senate, or they had a lot more of the Senate, you would see a lot more balance in the judges. The judiciary is just so empty at a point where it tilts to the right, which tends to be very anti-regulation. Fixing the filibuster, fixing some good governance items, I think would make a big difference here and possibly move it along in a better way. On the other hand, I think we need just to ask the courts to, show a little bit more discretion, show a little bit more respect to congressional authority to, try to really hard to regulate the financial sector in the way that was done after the New Deal.
I'm wondering how much of this is about financial regulatory reform or just the way regulation and the courts generally play out? I mean, we've seen before regulatory initiatives relating to environmental policy or consumer protections, when they come out, aren't they often challenged by business interests who don't want to see these reforms come online?
Absolutely. One thing that the piece doesn't get to is that this has been a problem for many parts of a progressive agenda, from especially within the environmental movement, especially with things like labor as well. The big problem we're seeing right here is that the rulings have come so out of left field. The rulings have been so overdone, and sort of the opinions given and the justifications for why these laws are being overturned are really unanticipated. So it's not like the regulators thought, well, this could go one way or the other, and we're going to hope it goes this way. They thought that they had a solid rule that would sail through the courts with maybe a minor challenge, and the courts are coming back way harder than anyone expected.
So despite all this, you were saying before that there does seem to be a sentiment on Capitol Hill that with particular parts of the financial regulatory picture, certain smaller things need to be worked on, namely too big to fail. Are you getting a sense that we might see additional laws coming out apart from Dodd-Frank? And if so, it's going to be in too big to fail, or is it going to be elsewhere?
It's a good question. So we're seeing movement out of the House Agriculture Committee committee about pulling back a lot of the derivative rules that have to do with inter-affiliate or cross-border derivative rules that Gary Gensler at the CFTC and the rest of the team there have done a very good job, I think, of trying to balance them to meet the needs of 21st century industry versus, preventing systemic risk. And those bills would just toss them out. So you're seeing, on one hand, a move to already start to deregulate it, even though it's not even regulated yet.
We're seeing a will to deregulate for derivatives, and we're seeing a will to regulate when it comes to too big to fail.
And that is bipartisan at this point. There are some Democratic House members that have signed up for it, unfortunately. On the other hand, you're starting to see some stuff about too big to fail. There's a bill that will probably be released by Senators Brown and Vitter, a very liberal and very conservative member of the Senate, that would dramatically increase leverage ratios and essentially capital that large banks have to hold.
Would that be on top of Basel III, or would that just throw it out?
In the draft that was leaked, it would replace Basel III, but it would be a significant increase over Basel III, perhaps even twice as much raw capital, depending on how you want to measure it.
Do you think it's going to pass?
I think it's unlikely to pass, but I think it's going to shape the debate, which is to say one of the solutions we have is we know if all these rules don't work, more capital means more stable banking system and less of a subsidy to too big to fail banks. So you would see that as part of whatever movement ends up coming out of it.
Really interesting talk. Mike, thanks for coming by and talking to us.
Thanks for having me.
That's Mike Konczal, fellow at the Roosevelt Institute here in New York City. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.